Perfect. Absolutely perfect. You
It
couldn't get
is.
any better than that.
No, you couldn't.
All right, folks. Well, hey, we are going to get started. This is Jordan Henry, Ryan Height here at the Phyllis Schlafly Center, and we have a very exciting topic to talk about today. Now, the entire news world has been rocked these past several days, and in case you've been living under a rock these past several days, Politico leaked a draft opinion from the U.S. Supreme Court regarding the case Dobbs v. Jackson Women's Health Organization. And the opinion that was leaked, that's only a draft, seemed to indicate the possibility of the Supreme Court overturning Roe v. Wade and subsequent case law, Planned Parenthood v. Casey, and all of that, and turning the issue of abortion back to we the people, which brings up a very interesting term or a set of terminology that might not be familiar to a lot of folks that are not in the judiciary. I'll put the same disclaimer on this one that we put on the last video we did. We are not attorneys.
You're welcome.
Yeah,
You're welcome. That
yeah,
we're not,
right.
we're
Yeah, as
lawyers.
evidenced by the fact that we won't be here for 3 hours and billing you by the hour. We are not attorneys. But the Phyllis Schlafly Eagles does have several in-house attorneys that we've been consulting on throughout this whole leak process. But honestly, even the biggest constitutional scholars are doing a lot of shrugging these days, it seems like. So it's interesting how much is unknown. One might call it unprecedented.
Unprecedented.
Or unrivaled, or unmitigated disaster, however you choose to describe it. But specifically, the terminology we want to talk about today is the idea of precedent, super precedent, super duper precedent, stare decisis, all those sorts of things that are right now up in the air. Because the idea of stare decisis is simply a Latin term meaning that the decision of the court should stand. So if the Supreme Court has ruled one way in the past, they should rule on current cases in a similar manner to how they have on the past, which of course brings up the idea of overturning a Supreme Court a precedent. You know, what has happened before. Can you do it? Should you do it? To what degree should you do it? And is there a barrier between overturning something if it's considered a super precedent? And so, with that, we have to define what super precedent means. Now, it's more or less a made up term here recently. The idea is simply this, that there are some cases that are so incredibly important, some legal principles and rulings are so incredibly important that they should be immune or at least resistant to being overturned. And the question then becomes, is Roe v. Wade one of those cases? Ryan, what are your thoughts?
I mean, I think that my opinion is probably in line with a lot of folks in the country when I say, it's one thing for a bunch of members of Congress to throw out Latin terms and make it sound good, make it sound like this is something that we should abide by. This is solemn. This is something that you should agree to as a nominee to the Supreme Court. But when you put it that way, a man-made decision, or even not here, this decision really, it's as conservatives view it, an interpretation of the law ought to be so infallible that it cannot even be questioned in the future. I'm not sure that any man-made law should be so infallible to the point that it is unquestionable. Now, if we're recognizing a principle, and this is, don't hear me say something that would throw out the Declaration or the Constitution. We're recognizing God-given principles. This is natural law that exists. We are recognizing it's there. This is a different thing. We're talking about man-made interpretations upon that law. I mean, if you want to go down that road, it's a very quick, you can start running up. Well, should they not have gone and overturned Dred Scott, where they decided that as a slave and a black man, you weren't a full citizen? I'm pretty sure we're all glad that wasn't considered an untouchable precedent. Although at the time it was a decision that was made, and it was probably popular with a large portion of the country. Brown v. Board of Education was a big one that stepped in and overturned, reinterpreted something that was there. I think a lot of people are happy that came in, but there's still this, you look at some of these landmark cases and say, is it really a good idea? And I would argue it's not, to ever put something like that on a pedestal so high that it is untouchable from being questioned and reconsidered, maybe massaged a little bit, even if it's not just being thrown out in the future. I don't think that we should ever be moving that far with some of these, again, man-made interpretations. We should always be open to change and reform, because bad decisions are made all the time. So that's my view,
Yeah.
at least.
Yeah, well, I would say that current Supreme Court Justice Amy Coney Barrett really put it well whenever she was put under the gun by Senator Amy Klobuchar on whether or not Roe v. Wade is considered a super precedent. She responded very well, I think, when she said that definitionally, a super precedent is something that is so incredibly settled that there is not an outcry from people trying to change it, because we just all as a country agree with something. And there are examples of cases that you could consider to be a super precedent, in the sense that we just all agree, yeah, nobody's trying to overturn that. It doesn't make any sense. So I mean, I think that, you know, the way that it's defined, you could say that those cases certainly do exist. But if you have to argue over whether or not something is a super precedent, then by definition, it's not a super precedent, you know? Because if there are people fighting over those issues, then it's not settled in the sense that it's beyond the ability for it to be overturned.
Yeah.
And I think that's especially true when you talk about a case like Roe v. Wade, where so much of it was based not only on differences of opinion, but on science, which changes so much and has changed, especially within the last 50 years. I mean, the widespread use of the ultrasound is the classic example that Phyllis Schlafly brought up so much, about how that changed everything. That changed our whole understanding of what it means for a child before he's born to be a child. And we could see that now. We see that evidence that we didn't see before. And there are plenty of other examples, DNA evidence that show that an unborn child still is entirely distinct from the mother. I mean, there is so much that has changed in the last 50 years. So to say that something like Roe v. Wade can be a super precedent that is resistant to being overturned, it doesn't make any sense. And even the justices at the time, as they were coming out with Roe v. Wade, admitted that the science might change on this.
Oh, for sure.
They openly admitted, hey, this is not a super precedent.
I appreciate that you bring up Amy Coney Barrett's definition of that, because when you look at it, you know, we were talking about that before we started the video. These words get thrown around so much: stare decisis, super precedent, precedent. But honestly, like, you know, we the people, the who give our consent to the government, the consent of the governed, we ought to know. So let's take a moment and let's help stop and say, what do these terms mean? Where did they come from? It's kind of interesting when you look at it. This term super precedent, I think, as we trace it back, it was Pennsylvania Senator Arlen Specter who was the first one. I'm sure many of you remember Arlen Specter. He was the first one to use that phrase during the 2005 confirmation of now Chief Justice John Roberts. And he was asking if Roe was a settled precedent of the court. And of course, Roberts didn't give him exactly the answer he was looking for, but Specter was the first one. Of course, he was a strong supporter of abortion rights. He was the first one to use super precedent. Apparently, and you've seen in our title, he also used the phrase super-duper precedent, which I don't know if we should refer to abortion as super-duper. That seems kind of morbid, even on the pro side. So that was a little odd. But if you look back, I think only in 2000 was the very first time this seems to have come up in an appellate court decision. Judge Michael Luttig in 2000 referred to what he called super stare decisis. But his definition, it sounds a lot like Amy Coney Barrett, which this is far from a definition that meets Roe v. Wade. He said super precedents are those constitutional decisions in which public institutions are heavily invested, repeatedly relied upon, and consistently supported over a significant period of time. They are deeply embedded into our law and lives through the subsequent activities of the other branches. Super precedents seep into the public consciousness and become a fixture of the legal framework. That is hardly something that you can apply abortion rights into that definition, since it's such a short, recent period of time in our entire American history, and it is so controversial. It's not just this automatic assumption that has seeped into the public consciousness is, oh yeah, well, that's normal. Oh, well, that's
Yeah.
like, that is far from it. And I think that that's one of the interesting things, again, as you qualified before we started this conversation. This is a draft that we're talking about. We don't know what the opinion is going to be. And it is unfortunate that the circumstances of us even seeing this, as exciting as it may be to think of the direction that they're going, looking at that draft, that seems to be kind of the prevailing. This is a very strongly divisive moral issue that is still being fought by public opinion. This deserves to be in the legislature. This is not something that the court, should interpret the law, because the common, the public opinion and the law is far from settled, because we have states going rapidly one direction on this spectrum and states going rapidly the other direction to pro-life and toward, pro-abortion rights. This is far from settled in law, so the court needs to take its hand off. It's far from settled super precedent. That's kind of the mentality that we get from this large draft document that we see, recognizing, precedent may exist, but this certainly doesn't count as super precedent. It's far from settled in the public opinion or in law.
Yeah, and there's one more point I want to hit on before we close this thing out.
Yeah.
But for those of you just joining us, hey, if this video is informative to you, interesting to you, please like, share, and subscribe to our channel so that you can get future videos like this, because we really are trying to take these difficult, fancy Latin words and to break them down a little bit so that the average person can understand it. So please help us out, like, share, and subscribe this video. And I will say that the whole super precedent thing, honestly, if I had to take a guess, I think that was made up on the spot. I think he was trying to think of some fancy Latin term, but he couldn't think of one, so he put super in front of something else in order to make him sound cool. But that's just me.
I hate to just have to agree with you, but anyone in a congressional hearing who says super-duper probably wasn't. I don't think that this was written down and thought of ahead of time. I have the feeling it was really definitely on the fly. So.
Yeah. But here's one controversial statement I want to make, and that is that another reason why I don't think that Roe v. Wade is super duper precedent is because of the fact that, in my personal opinion, I think that in the 1992 decision of Planned Parenthood v. Casey, I think that more or less overturned Roe v. Wade in a practical sense. Now, I know that the majority opinion in the Planned Parenthood v. Casey case, they said that they were upholding the essential holdings of Roe. Those essential holdings being that a woman has the right to choose an abortion prior to viability without undue interference from the state, that the state can restrict an abortion procedure post-viability, and that the state has an interest in the pregnancy and the health of the woman and the life of the supposed fetus that may become a child. And as far as I'm concerned, they can say that is upholding the essential holding of Roe, but I don't think it really is. Think about what else Planned Parenthood v. Casey did. First of all, Roe v. Wade established the trimester system, and saying that the states could not place restrictions on abortion prior to the second trimester. However, then they moved the standard from the trimester system to the even more shaky grounds of viability. So, I mean, to remove the trimester system from Roe and from Doe v. Bolton, I don't see how that's even the same case. As far as I'm concerned, that right there counts as overturning Roe in large part. And also there's the establishment of the undue burden standard, which was not there in that initial Roe and Doe cases. So I think that to make those kinds of drastic changes, like there was in Planned Parenthood v. Casey, I don't even see how you could say that it's been this way for 50 years.
Reaffirmed. It really is disingenuous, because they'll go, proponents of this will say that, it's being reaffirmed. Was it 38 times? I think they say it's been reaffirmed 38 times. Well, I don't know how, because there are the two major Supreme Court decisions, one 50 years ago, one 30 years ago, 20 years after this supposed super president. To your point, they essentially kind of gutted a lot of it.
Yeah.
And then, we're going to say it this way differently. Well, I don't know if we can then point back to the 50-year-old version and say that it's so much super duper stare decisis, because you just gutted it 20 years later. and replaced it with similar values but completely different framework, it's far from settled, and far from beyond being looked at and upended by a new court or a new system of justices. Of course, reflecting on the wisdom of the past and also recognizing unwise decisions.
Right.
So,
And honestly, I would say I don't think you're going to find too many people, too many legal scholars that would say that they want to go back to Roe v. Wade over Planned Parenthood v. Casey. It just, to me, if you had that level of a change in a case following something like Brown v. Board of Education, I mean, there would just be riots in the streets, and rightly so. So, to take something like Roe v. Wade that has been so dramatically changed over the last 50 years and to call that super precedent, to me, it makes no sense. Makes no sense whatsoever.
I agree.
So hey, we probably ought to wrap this thing up. But thank you all so much for taking the time to be with us here today for this discussion among us here, the Phyllis Schlafly Eagles staff. What did you think about this video? Is there something that we didn't clarify? Is there something that we missed? Do you have a different opinion on this? Is Roe v. Wade super precedent, or is there such a thing? Let us know your thoughts by leaving a comment on this video wherever you're watching it, and be sure to share with your friends. We want to get as many opinions on this as we can, because wow, it is a fun time to be alive, and so we all need to be very, very vigilant as we move forward with this.
Absolutely. Thank you, everyone. Like, share, and subscribe. Hit the follow button wherever you are. Hit the share button, like Jordan said. Share it with your friends and family, and we'll see you next Thursday, if we don't have some other special report that comes up in the meantime in the next 7 days. We'll see you next Thursday, and same time, same place, although we don't pick a time, so you'll just have to watch for those notifications, hit the little bell, and make sure you see it when we go live. Thanks, everybody.